And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I mean, that can't be chalked down to just White Claw withdrawals, right? I mean, she sounds like she just ran up a flight of stairs like 10 times going full Rocky Balboa. Hello, 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 and welcome back to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, and no, we are not tow truck drivers. We are just people who have opinions about all things going on in the true crime community, including Bev going through some kind of case of the White Claw withdrawals. I have no idea what this is in response to. All I know is that 1 minute I'm working on my laptop, right? Going through my day, and the next minute I go on Twitter for like 2 seconds and boom, it is completely flooded with clips like this about why Bev just dramatically decided to suspend yesterday's hearing after hearing about whether or not ARCCA should be allowed to testify in this upcoming persecution of Karen Reed on. Now it doesn't seem like it's going to go down April 1, so maybe that's why Bev has the shakes. I don't know, or maybe she just needs a White Claw. Somebody get this woman a dang six-pack. But thank you, Microdots, for this amazing video. This was nicely edited, spliced up, zoomed in, so let's check it out.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today.
I mean, she sound like, were you chain smoking with Adam Lally outside? You sound like you need to be hooked up to a dang respirator, girl, a nebulizer.
At 11 o'clock, and so I'll see you a week from today. At 11 o'clock in the morning, you can tell me now if that is impossible for you.
I mean, to be honest, at least she did her nail.
Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I really hope it doesn't boil down to like some kind of medical condition. But then again, I mean, people don't seem to have problem, at least witnesses in this regard, talking about people's medical conditions to their buddies. I'm talking to you, Chip Proctor. Yes, Hank Lynn, would you mind giving me the contact info to the federal government? You know, phone them up with 1-800 the feds, like the ARCCA hotline. I mean, you're not gonna call up Ghostbusters, but shout out to Microdots for putting this video together, friend of this channel. Please go give him a follow on all the socials, on Twitter. I think he's doing another fundraiser too. I'll plug that at the end of this video, but it just seems very out of character. I mean, we haven't seen many sides of Bev, at least in this particular case. It's really been just the deep sighs, the disappointed parent vibes, specifically aimed at Alan Jackson, which again, a lot of this, from what we just saw in that clip, stems from this motion that was argued by Hank Brennan at the very end, right before Bev decided to call recess, and then she disappeared into her chambers, and this was the reaction we got. She was gravely concerned, and I guess a breathless Bev is enough to even grab a headline from TMZ, one of the trashiest tabloids. I mean, that's how you know things are heating up when you get TMZ covering this clip. I mean, this was absolutely insane. So what exactly happened? Let's catch you all up to speed if you didn't watch yesterday's hearing. According to Boston Globe, prosecutors, Hanklin, alleges lawyers for Karen Reed improperly colluded with car crash experts who testified at trial. Talk about a headline, right? I mean, it's not like, Adam Lally didn't, coach any of the witnesses. So Hanklin, I'm just going to refer to the prosecutors as Hanklin from now on. So Hanklin, in the Karen Reed case, has accused the defense, namely Alan Jackson, right? Because clearly he's threatened by him. Defense Tuesday of improperly coordinating with expert witnesses who billed her legal team for roughly $23,000, even though the jury was told they were retained independently. Independently meaning by the feds. The Commonwealth just provided the court. You know what I find completely ironic is the fact that Chip Proctor was literally emailing Kevin Albert about potentially using the Canton Police Department to interview witnesses after they've already recused themselves in that part of the investigation. So, I mean, make it make sense. If you're talking about coordinating and colluding, all of these crazy conspiracies, right? Let's take a deeper look inside of that and see what's going on. But anyways, the Commonwealth just provided the court with information that causes me grave concern. Oh, wait, sorry, this is Bev. Different voice. The Commonwealth just provided the court with information that causes me grave concern, said Judge Beverly Canola Oil from the bench during a pre-trial hearing in Norfolk Superior Court. Canola Oil said the implication of the information may have profound effects on the defense and the defense counsel. And you can see in that clip too, I don't know if you guys noticed, I felt like she was staring like right into Alan Jackson's soul. She does not like Alan Jackson. I mean, even at the very end of this, when she's like, yeah, we're gonna meet up in a week, and if you can't make it, you can't make it. And sorry, AJJ, but if you can't be here live and in person, well, that sucks for you. I mean, she is just such a see you next Tuesday. But anyways, literally, see you next Tuesday. She did not elaborate. Yeah, she just quite frankly stopped all proceedings, even though there were a slew more emotions ahead. So the Crash Daddies, obviously, they testified during trial 1, persecution 1. Wolfe had told, so remember Dr. Wolfe and Rentschler. Dr. Wolfe I referred to in my early days as David Boreanaz, if you're a Buffy the Vampire Slayer fan. Yes, David Boreanaz. Alan Jackson on the stand that you have not paid us anything. Yes, he confirmed that. He explicitly asked in his line of questioning to the Crash Daddies, did I pay you? Did anybody from defense counsel pay you to be here today? Did we hire you? And they point blank said, no, sir. We were hired by an entity. Now, there was a lot of confusion that ended up coming to light post-trial about who that entity was because they were not allowed to speak about the federal investigation. Imagine being a juror and hearing like, hey, there's an investigation going on into the investigation of this case that I'm sitting on as a juror. I could be doing anything else with my time right now. But instead, I'm here listening about how high bar tabletops are and the snow. How much little, what if any, lack there of snow there is. Tail-like pieces revealing themselves. Ongoing testimony about Aruba. Oh my God, those dumb sisters. 10 weeks of nonsense while you're sweating your behind off. Only finding out until after the trial, after the mistrial was declared, that, oh, that entity, yeah, that wasn't an insurance company. That wasn't Turtle Boy. The federal government special prosecutor Hank Brennan said when Canola Oil previously asked Reed's lawyers if they had ever spoken to the experts before, remember they did the whole voir dire, yada yada, They responded that they had spoken with them to coordinate their testimony and backgrounds, but hadn't been able to interview them about their findings. So essentially, the defense was like, hey, backtrack it. The feds were like, hey, we hired these guys. Have at them. They are investigating this investigation. Who wants them? The Commonwealth said, no, we're not going to put them on the stand, even though they are clearly, they build cannons for frick's sake. But Lally was like, no, it's a better idea to put Trooper Paul on the stand instead as our to represent our case, right? Maybe that's why Brennan wants a fair trial, because he has he has the worst experts to represent himself. And so much so that they had to hire somebody to replace Trooper Paul because he was a freaking disaster. I mean, I don't know who was shaking more, Bev or Trooper Paul on the stand during the first trial, but so yeah, and the defense was like, no, this is great, because they've gotten down to the truth, which is usually what the state is supposed to do, right? They got the burden of proof. Meanwhile, the defense seems to be the only ones who care about revealing the truth and not just revealing taillight pieces. Brennan said the written record tells a different story. Emails provided to prosecutors under a court order showed that David Boreanaz, in March 2024, wrote to Reed's attorney, Alan Jackson, saying, please feel free to forward an engagement letter to this email address. I will get the countersigned and return to you forthwith, along with the retainer that's required. So we're going to play this clip in a little bit, but Wolfe then sent Jackson another note on June 22nd, a couple of days after his voir dire testimony out of the jury's view and 2 days before he testified in front of the panel. I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary, Wolfe wrote to Jackson, according to Brennan. Brennan then said, prosecutors also obtained an outline of questions and answers for direct examination of Wolfe by the defense. So he's really scared of David Boreanaz. I would be too, because Angel had a bad period, right? Like when Buffy and him did the deed, like he went dark. So maybe there's a dark Wolfe. His voice tinged with sarcasm. Yes, this was his like mic drop moment, although it didn't land. Hanklin said to prosecutors that prosecutors did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. So you're essentially admitting that they found the truth. They did the whole accident reconstruction. They built a freaking cannon, right? I think they even like tested multiple like cocktail glasses to see like, is anything gonna shatter this taillight? Is anything gonna do what happened? Whoever smashed up that taillight, is it gonna do the same thing? And it didn't. And it didn't. And it's like, I just don't understand why we're here and why it didn't compute. And I know Turtle Boy did an interview recently with a juror on camera, which should be reported about in mainstream media. I mean, what are you doing? Talk about a story. TMZ, hello. I mean, like, talk about tabloids, right? When do you get jurors on camera speaking to journalists? You don't, but hey, right? He's just a blogger though, right? Brennan said Wolfe also wrote in the margins of the outline, not sure if you want to put this somewhere in the direct examination. I have a feeling prosecutors are going to argue I didn't personally inspect the vehicle, need to show the jury it doesn't matter in this case. And that was the same exact argument too. Remember that they polled with Dr. Marie Slay the Day Russell, right? The dog bite whisperer. Is that, like, did you examine John O'Keefe's body? Well, no, I didn't. Like, no, but I've examined enough injuries that look like this, and I'm literally the baddest mother ducker in this courtroom right now. How dare you speak to me with that tone, sir? Because I am the well of all kinds of knowledge. I know everything. I am everything. Period. End of story. I mean, that's the response I had in my head of like how like she would respond, but I mean, she did it in a smarter way anyways. But but he was essentially like, yeah, well, you didn't examine the body. Well, I mean, even if they did examine the body, right? Of the people who did examine his body, clearly missed the day in class where they said, hey, if you're performing an autopsy on someone who gets struck by a motor vehicle going 24 miles an hour in reverse for over 62 feet, these are the injuries you can expect to see. One would imagine something below the collarbone, at least, like a couple bruises, scratches, something, but no. Instead, he looked like he went, what did Paul O'Keefe say? 10 rounds with Mike Tyson. So that message is not dated, right? So he's reading off these emails, only for Bev to ask, what's the date of that? There is no date. And interestingly enough, come to find out, the ARCCA experts' contract with the feds has ended. So Brandy Churchwell put together, go follow her, by the way. She's amazing. She has a podcast, really great podcast. She's been covering this pretty practically, as far as I know, like since day one, or at least since the first trial. Really, really in-depth, really interesting insights as well. 13th Juror podcast. But she put together this amazing timeline specifically centered around this ARCCA report, right? So the ARCCA report was done by 3 ARCCA experts who did their testing and came to the conclusion that the car damage and John's injuries don't add up. It's dated February 12th, 2024, before either side even knew ARCCA was involved. Both sides then got the same report, the same conclusions. We learned all of this before Voir dire Day, right? And no matter how much some people wish this somehow proved that the defense is responsible for those conclusions, it's not, right? If the glove don't fit, you must acquit. Those conclusions were read in open court by either side. Talk to anyone from ARCCA. So she shared this clip.
Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him, and he wasn't hit by the car. Period. Full stop. That's their independent expert.
Yeah, exactly. You would think that, the Commonwealth would be like, oh, well, you know what? Then we probably shouldn't continue prosecuting this woman because we can't prove that she was hit by a car. And nevertheless, I mean, this has been brought up so many times. I don't know why my mic keeps dropping. Mic drop. I mean, if it was in fact a motor vehicle accident, where's the freaking crash report? Where's the crash report, right? These are the questions I have, and I can't fathom the fact that nobody on the jury, I mean, like, I know it was a lot, and, like, your brain goes to brain fog sometimes, but, like, no one thought to say, like, hey, that's a little bizarre, like, where's the crash report for this alleged pedestrian strike? Because that's what they're alleging it was, but it wasn't. So look at the dates of everything below, even have the sources listed beside it, so check yourself. Makes you feel better, blah, blah, blah. Nobody lied about not being paid. The defense has not paid ARCCA, but even if AJJ slipped them an envelope full of money under the table, it still couldn't change the specific conclusions that were handed over in February. And that's a great point, too, as well. Like, it's like that still doesn't change the fact that Karen Reed did not hit John O'Keefe with her car. He was not hit with any car, period, end of story. Like, there was no motor vehicle accident. There was none of it. And then so we're going to take a quick peek at this. The bill for $23K to cover expenses or whatever it might be for is discoverable. And guess what? It was turned over by the defense in discovery. Exactly. They're not the ones withholding Sally Port video when the entire case revolves around a motor vehicle striking a pedestrian and unaliving him. Why wouldn't you provide a video showing you backing in Karen Reed's Lexus into that Sally Port to clearly show the shape and condition the taillight was in at the time it was seized? Why wouldn't you take pictures, Chip, of the taillight when you arrived on scene? Why didn't anybody from the Canton Police Department, when they first arrived, hey, let's take pictures of everything, right? Where's the metadata? Where's the chain of custody logs? Where's the evidence logs? Where's anything? If they don't exist, how is that not a problem? And again, shout out to Brandy for doing this, because this helps my brain kind of organize things a little bit better. But okay, so on February 12th, 2024, so last year, a report with findings from 3 ARCCA PhDs, Dr. Rentschler, Wolfe, and Klein, is dated and turned over to the USAO. Nobody from the Commonwealth or Defense knows anything. That was just the clip we played. This report was handed over before any expert had talked to anyone with the Defense or Commonwealth. The report contains 4 opinions. The ARCCA experts were allowed to testify to the first 3, but not the 4th. Again, they went through this in voir dire. I think that was like in regards to the medical condition. Then on the 21st of February, 2024, 3,074 pages are given to the Commonwealth and the Defense from the feds, including an ARCCA report. The Defense and CW see this for the first time. So together, AJJ on exactly a month later brings it up that the conclusions from ARCCA in the hearing, injuries are not consistent with having been hit by a car, damage to a car, or not consistent with having hit Officer John O'Keefe. Then, 10 days later, the defense contacts ARCCA to testify. He tells Dr. Wolfe he can send an engagement letter and required a retainer, but Dr. Wolfe responds, the USAO, the agency who hired them, said to pause and wait to hear back about their involvement going forward. So that kind of sounds to me that Alan Jackson was like, hey, I just know that you were hired by the feds. I don't know what your contract looks like. I mean, that doesn't sound really suspicious. It just sounds like he's like, hey, you seem like a good witness for this case that I'm defending. I would like to hire you if I'm able to, if I'm allowed to. That's not a crime. Inquiring to hire somebody, an expert to testify in a trial, a criminal trial, is not a crime. Now, if he had paid them and they did like an under the table deal, yeah, that would be like obviously 1, a breach of contract, and 2, that would be very unethical. But AJJ not knowing whether or not the contract was still ongoing is not a crime. So Yannetti tells Judge Beverly Canola Oil about his conversations with ARCCA experts. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in reports that both sides have. He was saying, remember, we only have what we were given. We cannot produce material and discovery items that we do not have ourselves because we did not hire them. They are not our experts technically. Yes, they are going to be called as defense witnesses, but we did not hire them. Lally has the same shiz we do. So then the voir dire happens. There's no communication other than exactly what he said. You can see this all from like the court TV stuff. Again, I'll link this in my show notes as well too, so you can follow Brandy and check it out. But then In June, on the 22nd, is when Dr. Wolfe puts together a brief outline of qualifications and attached his DNT list, tells Jackson to make whatever changes necessary. Again, that's for the testimony so that everybody knows, hey, this is what he's going to be testifying to. And then, I imagine that that's a normal standard practice, like the same way that Lally was talking to his witnesses before they testified, like that happens in court cases. Not coaching witnesses, like children, minor witnesses, and persuading them to lie about the about what steak, Karen Reed being upset about the nephew not eating his steak quick enough. I mean, what a dumb thing. It's so gross and so manipulative too. I hate when people bring kids into this, when it's just totally unnecessary, as if they aren't like traumatized enough. Then on the 24th, so 2 days later, they testify. USAO and ARCCA contract ends on the 31st of July. Then December 4th, so we're fast forwarding almost like 6 months. Commonwealth sends another 2E request. CW files a notice of intention to exclude ARCCA on January 6th of this year. USAO responds to the request, citing Fed statutes and regulations that restrict complete discovery, obviously, because that tells everybody that, yes, this is still ongoing. We're not done with this thing. AJJ then says he's calling ARCCA to testify again. U.S. Attorney said contract ended with ARCCA. Parties can engage with ARCCA for future analysis, but original materials are still protected. So whatever they did for the feds, they cannot use for this case, but they can testify based on their own knowledge. So yeah, I mean, the U.S. Attorney said, hey, I'm assuming that would be Leah Foley, who's the new one, who's the new boss, not Josh Levy. So I'm curious now. Now she's entered. She's entered the chat. Lots of people entering the chat. CW files motion to exclude ARCCA. Defense then turns over the emails, aka discovery for ARCCA. So the way that this laid out, it seems like the defense turns over these emails after they get permission from the U.S. Attorney that they have the green light to use ARCCA and to hire them for independent analysis. I'm sure we're going to find out next week because this involves Alan Jackson. And it's troubling when Bev is like, hey, well, if you're not going to be here live and in person, even though this literally has everything to do with you, that's too bad. You can join us over Zoom. Like, what a crab lady. Anyways, so after they turn it over, this is not even freaking, this is 6 days ago, not even a week ago. Defense files opposition to the motion to exclude ARCCA. It says they've turned it over everything to the Commonwealth pertaining ARCCA in the care, custody, and control of the defendant as required by Rule 14. There's a lot of Rule 14 arguments today. Yesterday, the CW had 2 opportunities to cross-examine, and they have the ARCCA reports. Again, this is what it comes down to. So then this is when Brennan reads the emails that were handed over by the defense in reciprocal discovery, but tells Canola Oil, this isn't information by the defense. Reciprocal discovery? This is the information provided by the federal government after numerous requests, 2-week requests, and insistence the best I can to get as much information as I can. So it seems like you gotta call 1-800-FEDS. I don't know. Your friends in the federal courts, because you're very familiar, Hanklin, with the federal courts. You kept reminding us about how familiar you are with the federal court. I know how the federal courts work, so I wonder if him and Morrissey are related. I just kept getting like this whole vibe from Hanklin that like he must have been a really annoying kid in school. Like the kid that always just had to argue about everything and always be right. And that's why he chose to be a lawyer because, well, self-esteem issues. Anyways, not that we all don't have them, but so this is his big stink, is this bill. Which again, according to the timeline we just went over, it seems like this was after the contract ended. Why would, and like that's the thing that doesn't make sense to me. Why would Alan Jackson purposely be like, nah, I'm not going to hand over these emails? Emails that were provided by the defense, there weren't dates on them, so you can't, I mean, if we're going to talk about evidence logs and chain of custody logs not existing, and I can't hand over evidence that I don't have, discovery items I don't have, well, then the defense can make the same freaking argument of like, well, if there's no dates on the emails, then the messages I'm sending you, if we're gonna play it like that. So he said Wolfe mentioned he could clear up a point about his professional experience when he testified. And then a bill is also sent from ARCCA to the defense for the $23,925. Brennan said that's not trial by ambush, that's getting duped. Canola Oil scheduled the hearing for next Tuesday, so we'll probably have a video on that the following day. I'm actually seeing a Predators game that night, so woo. It's common for prosecutors and defense lawyers to pay their experts, but jurors in the retrial weren't apprised of Wolfe's correspondence with Jackson. Neither side was allowed to refer explicitly to the federal grand jury at trial. No one has been charged with any federal crimes in connection with the Karen case, not yet. They couldn't immediately be reached for comment, yada. They also talked about, again, the Sandra Birchmore stuff. So I want to do that in a separate video because there was just a lot. There's so much. And this was like, just such like a, what is happening, right? Schitt's Creek moment. So, now I want to actually play the clip. Right? So we have all this build up now. This is the clip in full. I'm going to speed it up because I literally cannot stand this man.
So next, we'll move on to the so-called ARCCA motion. Commonwealth's
The so-called ARCCA motion by the so-called FBI, by the so-called ARCCA experts, so-called Crash Daddy, so-called David Boreanaz Angel,
motion to exclude employees of ARCCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
Oh, yes, take your time, take your time. Side note, that beard on AJJ looks fully throated.
Your Honor, my purpose is not to deprive the defense of an expert, or deprive the defense of an ARCCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness.
Because the Commonwealth deserves a fair trial. I thought the Commonwealth and the state had the burden of proof. I mean, last time I checked, it's been a while since I've been in school, but
It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is
I mean, it certainly was for the first trial, so
other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about, they can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed,
well, hold on a minute. Let's talk about collaboration. What about your collaboration with Michael Morrissey's, or what is it, Cheesy Banana? Now he goes by, he's no longer a meatball, he's a Cheesy Banana. It's like, Cheesy Banana, Meatball Morrissey, and going through his cell phone. What kind of collaboration do you have with his phone, right? You're manually going through his texts.
Then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery.
What about the 3-year-old videos from the Sally Port that we just got, bro? What about that? What about that they're still getting drips and drabs of? And yeah, you can, clamor on your soapbox all day long about, I didn't know, I was just hired back in September, blah, blah, blah. But still, what about your counterpart who's sitting right there, lunchbox, twiddling his thumbs? What is he doing, right? Why? I just it's like, what's the point of having Lally there when like half of this like poop show was created by him, right? What about his collaboration with the investigators in this case and receiving certain evidence? I mean, you can't just chalk it all down to, well, I just, if it doesn't exist, like, I can't hand it over. It's like, well, why doesn't it exist? Or why are things just magically revealing themselves? I mean, I almost don't buy that these evidence logs and the chain of custody logs don't exist. I feel like they do exist. What about the ring camera footage that was promised in the very, very beginning? What about that? If I keep doing his voice too much, I'm going to start sounding like him.
Now, I wasn't at the last trial, but I've read the transcripts. And on June
you?
10, 2024, you asked the defense about ARCCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 28,
Bev's like, you're talking about the feds. I'm getting nervous. She's starting to sweat a little bit.
12 and 2813 of June 10,
What did I say?
2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government, and I tried to encourage them
1-800-EMPIRE today.
to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial.
So you're okay. All right. Thank you for clearing this up. So you were blatantly admitting that you have not watched the trial. You've skimmed through the transcripts. So you have an idea, a basic general idea of what you're prosecuting. I guess, I mean, that is worth the $75K, like that, the $250 an hour, like you're going to do the bare bones minimum. I mean, I have a flavor. What does that mean? What does that mean? I have a taste for what's going on, but you're the lead prosecutor. You're the special prosecutor who taxpayers are paying more money to prosecute A factually innocent woman for the second mother-ducking time. But I only have a flavor for it.
So there is email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. It relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we receive additional information from their office regarding how our involvement will move forward. Now,
So that's all the stuff that we went over in the Brandy Churchwell spreadsheet. So I'll share that again in the show notes so you can follow along as he's talking through these dates.
it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can.
So again, it seems like you have a problem with the federal government, which I mean, and a lot of people pointed this out too, and I think it is a good point, is, I mean, it's clear who he's repping. He's repping, I mean, this is obviously my opinion, but he's clearly repping Cheesy Banana Meatball Morrissey, right? And he's trying to beef up his case to protect him, which is like you're protecting like one government employee against a government entity. Like it's just such a weird, like very bizarre position to be. But it seems like his issue is with the federal government, which again is not the defense, right? Is not Karen Reed, is not their issue. They received what they received. They handed it over. And again, if you're going to make this whole argument about, well, we don't have certain discovery items and therefore we cannot produce and send them your way and share them with you, then we can't, right? If they don't exist, we can't hand something over that doesn't exist. You can't make that argument and then 20 minutes later circle back and argue the exact opposite of that, complaining and moaning about why you haven't received information from the defense that they themselves have also not received as well. From who? The federal government. So again, it's like, what is this all really about?
We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth.
So you admit
What
it's
follows
the truth.
from this outline
So you admit that their analysis is the truth. Okay.
is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less.
I think he knows the whole they're not qualified as experts argument didn't really hit well with Dr. Maurice Lay the Day Russell, so.
In this case, than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me...
Just like any video footage, period. The library footage, the missing Sallyport video, the video footage of Brian Higgins, one of the biggest witnesses in this case, outside making a phone call when he lied. He lied to the grand jury and lied during this first trial about making any phone calls during the time that he made a phone call in front of where? The Canton Police Department when he was allegedly, I guess, playing bumper cars or whatever.
Me to say this, that's fine. That's fine. Shh. Don't tell them.
Shh, I'm done with you.
Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
You know, I honestly, legitimate question. I wonder if he's taken acting lessons, because this feels like a scene study class where he's like he's doing a film acting scene and he from like Law and Order or something, right? And he's the one who's off camera reading off lines to Bev, and then she's supposed to deliver. I really do feel, because a couple of you guys have like pointed out, this kind of feels a little bit staged, and it really does. It feels like a performance. Acting though, not his best skill set. I wouldn't even recommend sticking to lawyering. I mean, I don't know what kind of capabilities he actually has as an attorney, because this case is just so bizarro that I just feel like I feel like I'm watching a David Lynch movie. Like, what I'm seeing is not actually real or happening.
And then a bill from ARCCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
Hanklin, we're gonna need a little bit more from you in the second take. I mean, you were really starting to come to light there in the end with the tap. There's too much tapping with the mic. It picks up everything. So let's do it again. We'll take 2. Let's go back and do this all again.
I'm going to take a recess before the recess.
All right, please.
Excellently delivered by Beverly Canola Oil. So yeah, she's like, yeah, I gotta go. And look at this mother ducker run. She's like, skirt. Okay, bye. See you all. Like, I have it on 1.25 speed, but she is like, bye everyone. And then she takes a 30-minute break to do, I don't know, maybe she just had to go potty, guys. I mean, maybe we're all just overthinking this, and it's as simple as, guys, I had a little too much coffee this morning, didn't expect it to all hit me at once. I gotta go, I gotta relieve myself, I gotta reveal some taillight pieces in the porcelain throne. I'll see you in 30. Like, I don't know, but whatever, like, that warranted something in between Hanklin saying that and the 30-minute recess. Something happened. Something had happened. I don't know if she got a phone call. I don't know if she made a call to somebody. she had too many smokes in the back with lunchbox. I mean, I don't know, but I would love to know what you guys think, because whatever the case, Team Karen Read is a coming out swinging. I posted this yesterday on my community tab. I've been a little bit quiet this week on Twitter just because there's just a lot going on. Last week was a trip, but yeah, Christina Rex, I mean, not my favorite reporter, but yeah, it's been confirmed. So this is yesterday. Karen Read's team has now applied for relief from 2 of her charges, the M2 and then leaving the scene charges in federal court. So remember, she made the appeal with the SJC. They denied that appeal. I think that was just last week, actually, that happened, or the week before. And that was within the Massachusetts state courts. Now she's going federal, guys. She's going full-on gangster, right? Asking the U.S. District Court to consider her double jeopardy claims that were denied by the SJC, and there is a hearing for that on March 5th. So I'm assuming Marty Weinberg will be making a return to the stage very, very soon. That won't be obviously streamed, but it'll be reported on. So as updates come in, we will update you here. But I also just wanted to share this from another fan favorite here, Dag Nabbit. Again, go follow all these guys if you guys are on Twitter. Attorney General Campbell has now entered the chat, right? Lana Del Turtle, another great account, made an observation. So by filing a plea for relief in federal court yesterday, Karen Read's attorneys have drawn Andrea Campbell into the fray, who's been very active about taking down the Trump administration. I guess she didn't see this one coming. So Karen Read's coming after you, Andrea. You got a lot of stuff to answer for. I mean, we still have Enrique Delgado Garcia. We haven't heard. How long has that been? It's been months. Months and months and months and months. Still no answers as to what happened. You think making a guest star appearance will show yourself at the graduation ceremony for the MSP recruits, the graduation he was supposed to be at, you think that's fine, all well and good, and you just move on to bigger and better things, right? Well, not so much. Until now, our Attorney General has been frustratingly and cowardly silent about the disturbingly plausible allegations of deep police and prosecutor corruption in the most controversial unaliving prosecution here in, well, forever, yeah. But with this federal suit, Karen Read's attorneys are pulling Campbell's head out of the sand. Attorney General, along with Norfolk Superior Court, which would mean Beverly, is named as a respondent in this case. There was 700 pages, guys, 700 pages. I don't know who's going to do that stream, but woof, that's going to take a minute. And must file an answer to the federal judge, Saylor, by February 26th. So they don't have a lot of time. I mean, this is one day after that hearing. So I almost wonder if that 30-minute interval had something to do, like she got a tip off about, like, hey, this is coming. This is coming your way. Sit down, have a White Claw, chill out. But this is coming your way, and you're going to be named in it. I mean, that to me is huge. Addressing why she, as the state's top prosecutor, believes Karen Read should be retried for unaliving after the jury in her first trial unanimously acquitted her. Federal filing is not an appeal of the recent SJC decision. Technically, this is a new case and filing in which attorneys Weinberg and Pabian are seeking emergency relief from the federal courts because they claim Karen's constitutional right protecting her from double jeopardy on the unaliving charges is being violated because, yeah, they are. Judges are appointed for life, so Canola Oil is likely unfazed by being called on the federal carpet. But attorney generals have to face the voters every 4 years. That's a great point. I wonder where she is. Where is she at? While it's clearly been politically expedient for Campbell to pretend state police and Norfolk DA's office have not been running amok, name that movie, over justice and defendants' rights the past 5 years or more, Campbell has no longer has the luxury of cynicism. Will she double down on protecting Meatball? I mean, who would? Like, it's like, I just don't get it. This like stuff feels like the frickin' mafia, right? I always say like this really does feel like the mafia, and it's so funny because everybody wants to talk about like, oh, the conspiracy with the free Karen Reed pink people crowd, like we're the crazy ones. But it's like if you really buy into this narrative of the federal government conspiring with the defense of a woman who's being accused of drunkenly hitting her boyfriend and unaliving him with her car because they have nothing better to do. She's not a woman of society. She's not a political figure. Nothing has shown me from the Commonwealth that there's anything remotely that could connect Karen Reed and what happened to her boyfriend, Officer John O'Keefe, and his death. There's nothing, not one piece of evidence. Hanklin wants to talk about apparitions and ghosts. What about the ghost of all the people that just magically appeared, magically revealed themselves in that Sallyport video, right? Where the 45 minutes of footage is completely missing. I mean, it's absolutely insane. And this is why it really does feel like a David Lynch movie, because I feel like what I'm seeing is not all it seems to be. It's just an interpretation of an interpretation of another interpretation. And I'll tell you, honestly, we are not going to stop fighting this because this is disgusting. It's upsetting. It really upsets me. I mean, of course, for Karen Reed and her family, I can't imagine the strength you have to go through this. Like, talk about a strong friggin' person. And super smart and articulate. But I also feel so horrible for those kids being dragged through this. Let me know what you think about all of this in the comment section below. I want to hear your thoughts, feelings, fears, predictions. That being said, if you enjoyed today's content, make sure you hit that subscribe button. Make sure you hit that notification bell so you do not miss the next Karen Reed video from me, which will probably be the Sandra Birchmore stuff, because there was a lot about that with Trooper Carino. And make sure you hit that like button because that tells the YouTube algorithm that this is newsworthy news, and it is. My good golly gosh. I think it's important to have more of these conversations and get the truth out, because it's clear that Cheesy Banana and Meatball and Friends don't want us to know the truth, right? They don't want the glaringly obvious truth to come out, because I guess it's more important to protect your friends when you're in that little circle jerk of Sweaty Meatball and Cheesy Banana. So I don't know what Meatball has on Hanklin. I have no idea. But that being said, I will see you all in the next video.